So, friends, as we all now know, in the wee hours of Saturday morning, the United States Supreme Court ordered the Trump administration to stop writing. The government, the Trump administration, is directed not to remove any members of the putative class of detainees from the United States until further order of this court. Then, on Sunday, this guy, John Sauer, one of Donald Trump's former criminal defense attorneys, who is now Solicitor General for the United States, filed something in the Supreme Court. And if the name John Sauer sounds familiar to you, maybe you will recall that there was an attorney who argued in court that a president of the United States should be able to send SEAL Team 6 to take out his political opponent with complete immunity from prosecution, can't be held criminally responsible for ordering SEAL Team 6 to do that, unless Congress impeaches and removes him, which is an argument that makes no sense, no common sense, no legal sense, no constitutional sense. Yes, that John Sauer. So Sauer filed something with the Supreme Court asking the court to reverse itself and, let these deportations of Venezuelan immigrants commence. We're going to have a quick look at just a little bit of this new court filing by John Sauer, and we're going to look at what he chose to include in the court filing with the Supreme Court, and perhaps more importantly, what he chose to omit, what he didn't tell the Supreme Court about what's really going on here. So this is respondents' opposition to emergency application. And what I'd like to do, friends, is read a sentence or two and then translate it from legalese into English and try to figure out what it is John Sauer is saying and what he is choosing not to say, what he is choosing not to tell the Supreme Court. This court, the Supreme Court, clarified that as a matter of due process, AEA, Alien Enemies Act, detainees must receive notice after the date of this order that they are subject to removal under the Act. In keeping with the context-sensitive nature of due process, the court did not mandate any specific notice procedure. So first of all, what he's saying there is, obviously, the Due Process Clause of the Constitution requires that the federal government, the Trump administration, the executive branch, give anybody they are intending to deport their due process rights, which they had not been doing previously. Those due process rights, generally speaking, involve notice and opportunity to be heard. What is notice? Notice means you have to put the person on notice, formally, generally in writing, in terms that are not only understandable but understood by the person against whom you are now acting as the executive branch. Plus lawyers are ordinarily involved. Notice is not just, psst, we're shipping you off to El Salvador tomorrow, pass it on. No, that's not effective notice. That's not sufficient notice. This is not a damn game where you hope you can run out the clock and get people out of the country before they have a legitimate opportunity to be heard in court with their lawyer, make their case, present evidence. So it's really interesting and a little curious that John Sauer feels compelled to say, well, given the context-sensitive nature of due process, you didn't tell us what kind of notice we had to give. Put a pin in that, because that's a tell. Let's go on to the next section. The applicants, meaning the Venezuelan immigrants the Trump administration is trying to deport, ignore that the government, the Trump administration, has provided advance notice to AEA detainees, including the named petitioners, prior to commencing AEA removals, and the government, the Trump administration, has agreed not to remove, pursuant to the AEA, those detainees who do file habeas claims, including the putative class representatives. So let's translate that one, friends. That is John Sauer asserting that, well, we already gave everybody notice. And plus, we promise that if after giving them notice, if they want their opportunity to be heard, we won't deport anybody. Scouts honor, trust us, we're Trump lawyers. That's essentially what's being communicated in that passage. Let's go on to another passage. A few pages later, they emphasize it again. The government, the Trump administration, has agreed to forego removing the named petitioners pursuant to the AEA while their habeas proceedings are pending. So, friends, they say it a second time there, apparently for emphasis. Trust us. We pledge not to remove anybody until, they have their full, robust due process rights of notice and opportunity to be heard, honored. But you know what? You can read that new court filing front to back, back to front. Nowhere will you find information that was reported out by NBC News about a midnight run where Trump administration officials took a whole bunch of Venezuelan immigrants who were being held at an ICE detention center in Texas, stuffed them on the bus, and headed for an airport, the Abilene airport. And then there was some emergency litigation unfolding in court. And as that was happening, late Friday night into early Saturday morning, the reporting, complete with video footage, is that the buses went past the Abilene airport exit, turned around, came back, and redelivered those Venezuelan immigrants to that detention center. Not a word about that, let's call it curious midnight run. Were they just taking those detainees, out for a field trip, get some fresh air out beyond the four walls of the detention center in which they were being held? There's not a word about what in the hell that was all about. But, Trump's DOJ lawyers say, trust us, we wouldn't try to circumvent the Supreme Court's ruling. One more passage I want to cover. On page 13, they circle back to the notice issue. Although the government, the Trump administration, maintains that the notice provided was adequate, individualized factors, including a detainee's language ability or the family's pre-existing relationship with a lawyer, may well be relevant to a court's determination of the adequacy of a particular notice. So, friends, remember how a few minutes ago I said, wait a minute, there is a tell in what John Sauer decided to include in this court filing when he said, in keeping with the context-sensitive nature of due process, the court did not mandate any specific notice procedure. And now, here we have it. They say, well, there may be some individualized factors that come into play as to whether the notice we gave was sufficient. Individualized factors like a detainee's language ability. You know what we're probably going to see in future litigation, friends? This is just my suspicion based on John Sauer trying to get in front of an issue that's coming. I mean, that is dropped in the middle of this pleading on page 13 for no apparent reason. Could it be that Donald Trump's ICE officials are just giving these detainees notice in English, and many of them perhaps don't speak or read English, and then they're going to say, well, they didn't invoke this right when we gave them that notice, so we put them on a bus in the middle of the night and headed them out to the Abilene airport before we realized we better turn around, because if we do that, we might be caught red-handed, right? That is sort of one logical conclusion, reasonable inference based on the way this was unfolding in the wee hours of Friday night into Saturday morning. What notice and opportunity to be heard mean in the context of the constitutional due process guarantee is actual notice, advanced notice, intelligible notice that a person understands and can have a lawyer assist under, the Sixth Amendment right to counsel and all. But the good news is, it sure seems like the federal courts, the trial court judges, the appeals court judges, up to and including the Supreme Court, are about done, are about fed up with these stupid games that the Trump administration has been playing with the constitutional rights of human beings. And they should be fed up, because justice matters.